Well, welcome back, everyone. This is Ryan Woody along with Nancy Case and Catherine Dowie. And this month, we're going to change up the format just a little bit into a mailbag format where we're going to answer some of the questions that you guys sent in. We received a number of questions. Some of them shared some similarities, so we kind of combined those into, single topics. I would say that many of the questions kind of focused on practical advice, related to best practices for subrogation file handling. And so we're going to cover a lot of those. But we also received some questions about the status of the Roundup cancer litigation. So we're going to kind of take it in depth into the status of that and trying to figure out, when you're going to see your money on that one. Without further ado, let's start things off. Question has to do with pre-suit reduction demands. Lately, we've had a lot of attorneys wanting us to reduce before they negotiate for a settlement. However, we typically need more information about settlement amount, liability, and damages before we can make a reduction decision. How do you recommend we handle these pre-suit reduction demands? Catherine, you want to take this one?
So this is a tactic we're seeing more and more often in cases, essentially ever since we started getting some of the really favorable Supreme Court rulings like McCutcheon, because good plaintiffs' attorneys know that, pre-suit, before they've invested a lot of resources into these cases, this is where they're going to have the most leverage to potentially be talking about a reduction for attorneys' fees and costs or for some sort of division of a limited policy, because it's very true that in your run-of-the-mill case, if they accept, let's say, a limited policy and put that in their trust account and then come to you and say, hey, we want to make sure our client gets something, we want to do, let's say, a three-way split or something like that, if the plan just says no, there's really very little leverage they have at that point if the plan is willing to pursue a federal case, a 502c3 case. So when somebody comes to you about a pre-suit reduction, there are a few things you need to keep in mind. So are you dealing with a case where there's a huge lien, or at least the lien is going to become huge and there's a limited policy? And so the attorney comes to you and says, we'd like you to cap your lien at a third of the settlement, at 50% of the settlement. But right now, it's our understanding that the policy is only, let's say, $100,000, and so we know there's never going to be enough. At that point, the plan really does need to make a decision. They can either say, okay, we'll come to an agreement that, assuming that's really all there is, if that turns out to be true, we'll talk to you about that reduction now. Or the plan can turn around and say, no, we're not going to make a deal now. And at that point, the attorney needs to make a decision. Either he's going to say, all right, if you want to subrogate, go ahead, but I'm not going to put any more work into this if there's a chance I'm not going to get paid. And my client isn't going to put a ton of time or energy into building the kind of record that they might need to build in order to get a settlement that they won't actually benefit from. There are a few reasons that can be problematic for the plan, in part because it's challenging to get a liability settlement if the participant isn't cooperating, if the participant isn't going to sign off on some kind of settlement agreement. And we'll talk about that in a little more detail when we talk about, what factors should you consider in actually subrogating. But in short, if there's a limited policy, the plan has a choice to make. It can either do the reduction a little earlier, or it can call the attorney's bluff and say, fine, we'll go ahead and do it ourselves. So that's, I'd say, the most common situation where we get these kind of pre-suit demands, where there is this limited policy. Maybe there's already been an offer for the limited policy, but we know that there's just not enough money to go around. The other couple of situations where we get it are either cases where there's going to be some significant dispute or challenge to proving liability. We'll often get a request for a reduction for a share in attorney's fees and costs up front. This is particularly true in cases that are more expensive to bring, like medical malpractice actions or slip and falls, where even if there's not necessarily a limited policy, there is an expectation that there's going to be a limited recovery at the end. And those also should be evaluated on a case-by-case basis. But if you're dealing with a situation where there is plenty of money, where it seems like at the end of the day there will be sufficient money to go around, one of the responses that the plan can give them is to simply say, no, we're not going to come to an arrangement now. There's not a reason why we should come to an agreement now, because it looks like liability will be, a fairly standard thing to prove. And there will be enough for you to get paid, for your client to get something, and for the lien to ultimately be satisfied. And so,
let me ask you a quick question, Catherine. Now, what happens if this pre-suit negotiation doesn't always fit into the protocols that we might have in place for taking offers to the plan administrator if we're handling this as a TPA or a subrogation vendor? Are these sorts of offers that we need to take to the plan administrator for consideration, or can we just, as a matter of fact, reject them and call the plaintiff's lawyer's bluff?
So I would recommend that you would talk to your plans about these kind of offers. And so if an individual plan wants to establish a protocol that they're never going to consider them no matter what, I don't necessarily know that I'd recommend that a plan make that protocol, but that's ultimately the plan's decision. But one of the things that I've had to talk plenty of clients through, and this includes both subrogation vendors and TPAs and plans that I've worked with who aren't necessarily expecting these questions so early, are the fact that just things have changed in the last few years, and the strategies that we're seeing employed by plaintiffs' counsel have changed in the last few years. And so, whatever their decision is, they don't have to accept them, but the plans really do need to accept that these are requests that they may be getting and that they may need to evaluate to determine, is this ultimately in the best interests of the plan? Is this going to be the most cost-effective means to recovery? In some of these really limited fund situations, it often can be. And in some cases, it's a matter of, okay, the plan needs to know early on that there's a real chance that the attorney might drop this case and we may need to bring in our own counsel. And remember, we don't deal with this as often as the recovery vendors don't deal with this as often because you're so often dealing with reimbursement. You're very rarely dealing with subrogation. But in cases where the plan is seriously being asked to consider subrogation, you need to think of a bunch of factors that aren't going to be present in typical cases. Are there witnesses you need to talk to? Do you need to get an expert report? Is there evidence that needs to be preserved? Are there, are you dealing with a governmental defendant where there's going to be some sort of requirement that you provide notice to them that you're presenting a claim within 90 days or your rights may be voided? And so you don't want to leave yourself in a situation where those steps aren't taken early because you thought the plan might push back on whether or not it's all right to even consider these offers in the first place. So we would highly recommend that you do bring these offers to the plan when you're getting
them. And that makes sense. And that it kind of dovetails into the next question that we got is basically a variance on, when should we be subrogating? What claims are appropriate to even consider that on? Because, they're really few and far between since we rely on reimbursement so much. And I think, to give a good lawyerly answer, it depends, right? It depends. I think that deciding as to whether you want to subrogate and, step into those shoes of your member and pursue an actual negligence or, plaintiff looking tort claim is it's a complex one that requires you to have to be able to make a detailed assessment of the liability of the case, what claims you have and how you're going to prove them, damages, because just because you've paid certain medical expenses under your plan doesn't necessarily mean that you can recover them in a subrogation action. You've got a different, much higher burden of proof to prove that those are causally related to whatever particular accident you're talking about. And then you've got to consider the associated costs. Maybe you're going it alone, maybe you're intervening and becoming a co-plaintiff with your member, but you still are going to have costs, and those are going to be attorney's fees. They're going to be the costs of whatever discovery takes place. We're likely going to be having depositions and attending depositions. We're going to have to pay for those court reporter fees. There might be travel expenses. We may have expert witness expenses to think about. If we're proving up our medicals, we would probably need, at least on the conservative side, some sort of a records review by a doctor. And so those are all things that we want to be thinking about when we're talking about whether we're subrogating. It's not necessarily an easy call. And that's really when I think you want to consult with, attorneys, whether it's us or someone else that you use, as to what the cost benefit analysis of a subrogation action might be. The other thing that you've got to consider from a high level is whether you can even subrogate in that particular jurisdiction. Because when we rely on reimbursement, we aren't worrying so much about what the state laws are, because generally we're able to preempt them through ERISA. But if we're subrogating, now we're talking about individual state laws that we may have that may implicate whether we can even bring a claim. There are states like Arizona and California that are anti-subrogation from the standpoint that they will not recognize a subrogated claim by a health plan because it's outlawed by state law. And because we're bringing a claim against an at-fault party who is not a participant in our plan, we don't have that ERISA preemption to fall back on. And so those are things that you've got to be cognizant of, especially if, as we talked about in the answer to the last slide, if you're thinking about calling a plaintiff's bluff, you better make sure that you're in a jurisdiction where you can actively subrogate. Catherine, Nancy, any other thoughts you want to add on that one?
It's not a bad idea to contact colleagues who are personal injury attorneys and just try to run the scenario by them and see what they would have to say about it. Would they be willing to accept such a case? And obviously you can't give them all of the details, but you can get a pretty good feel for moving forward. And it's a good conversation to be able to have with your client that you did run it by a few personal injury attorneys in the jurisdiction and what their thoughts were, because they'll be able to tell you likely who defense counsel will be, who the judges might be, how the jury will act. So, I try to do that. If it really gets close to subrogation, before I have a conversation with my client, I like to talk to a few personal injury attorneys, see what they think about it. So it always pays to be friendly with them in that instance.
And I will tell you just a couple cases where if you've relied on reimbursement throughout and there's been a settlement, and now you're coming to me and we're trying to figure out whether we have a right of reimbursement, there are two types of cases that I regularly would ask you to look at early for potential subrogation rather than waiting until the end. And those are cases where you have an injury to a minor, and we have a question of whether the medical expenses belong to the parents or the minors, and there's potential for shenanigans regarding waiving those claims and settling only the claims that belong to the minor. Now, there are certain legal arguments around that, but I think a lot of times in those situations, it can be much cleaner for us to just intervene into that case and assert the subrogation claim for medical expenses. So too, where we have a death, where there's a potential wrongful death and survival action, because each state statute is not the same, and there are some states where we have to be cautious because they might not be pursuing a survival claim based on the cost-benefit analysis to the plaintiffs. Is why should we pursue that claim if we have to reimburse the plan? We can easily just pursue a wrongful death claim. Maybe there's policy limits issues. Maybe there's damages caps. I don't know. Well, those are the ones that are much harder to unwind through reimbursement if we let the underlying tort statute of limitations pass and miss our opportunity to potentially subrogate that particular claim. So those are two that I would definitely flag early on. Know your state statute of limitations for those claims and think about whether subrogation might be appropriate there rather than waiting until the last minute on a reimbursement claim. Moving on, so we got a couple questions that were I felt were related. Maybe they don't stand out necessarily as related, but I think that they are. So first, I'll just read them together, and we'll kind of go through the answer. So first, our team has been seeing a lot where the plaintiff's attorney sends us a copy of an order from the court, basically saying that the member was not allowed to introduce evidence of past medicals. Then the attorney for the member uses this to say that the ERISA plan cannot assert a recovery interest on the settlement in the case. So that's, again, it's very common in some of the collateral source states that don't allow the plaintiff to claim, past medical expenses that have been paid by a collateral source payer. And then the other question is under Iowa's MedMal law section, the Iowa Code section 147.136, medicals are not recoverable. Therefore, Iowa's attorneys tell us that we cannot collect on our ERISA liens. There are arguments going both ways on ERISA preemption, but mainly it seems like the plans are losing those arguments. How should we handle these claims? Can we recover? Great questions, everyone. So here's why I think the questions are related. So in my view, if we're seeking reimbursement through a 502(a)(3) action, and we've got an issue about the for example, in Iowa, the exclusion of medicals under 147, 136, in my view, preemption really isn't the issue, because it doesn't matter necessarily whether your personal injury plaintiff or your participant can recover in a MedMal case if the plan specifies that it's going to be reimbursed no matter how the recovery is characterized. Then we're just looking at whether the language is enforceable according to the express written terms of that plan subrogation provision. So in that way, it's basically the same if we're in a collateral source state where those medical expenses can't be recovered in that same way, is that we're not asking in the language of the plan, assuming we've got broad language, we're not asking whether the plaintiff has specifically recovered for those medical expenses, only whether he has brought a claim that is related to what we've paid. And if so, then our language is broad enough, hopefully, to be reimbursed no matter how the recovery is characterized or what it's for. I've given you a couple cases here down here. One is the Virgilino case, and that was a case involving a minor. Came out recently from the 8th Circuit. I believe it originated from Nebraska. And the issue there was, look, the parents' claim, the claim for the medical expenses belonged to the parents. And the parents had long ago not brought that claim. The statute had run. Later, the minor grew up, and he brought a claim when he reached the age of 18, I believe. And so that there was a savings provision in the statute of limitations there. And then the argument was, look, he didn't have the claim for medical expenses. He didn't recover for medical expenses. Therefore, ERISA plan, you cannot recover for medical expenses out of the settlement. But the court basically looked at the language of the plan and felt it was broad enough to cover for any recovery that was made in that situation. So too in the Mackey case, which came out of Minnesota involving a wrongful death claim, the argument was you couldn't recover medical expenses under the Minnesota wrongful death statute. And the court looked at, well, they had argued for medical expenses as part of their mediation submission, and the settlement release included a release of all claims. So arguably it was included, but nevertheless, the plan language was broad enough to cover it. And I will give you one caveat though, since we mentioned Iowa's Med-Mal statute, it doesn't necessarily mean that you can recover each and every medical claim you paid, regardless of your language. There still is some burden here to go through your lien and be able to show what is specifically causally related or connected to the medical malpractice that's going on versus what was maybe either would have been occurred regardless of the medical malpractice, or was certainly not related in any way. So I don't know that threshold, that burden is the same as the plaintiff would have in proving his medical malpractice case. But again, you've got to be able to show some causal relation. Nancy, Catherine, what do you think?
Yeah, so I'd say the big issue with causal relation, and something I see in matters that are, even get so far as referral to our office sometimes, is that, obviously in medical malpractice, at a minimum the date of accident, usually, the patient was receiving some kind of medical treatment that was required when the malpractice occurred. And so in particular, be careful and look and talk to plaintiff's counsel about what exactly happened on the date of accident. What was that person in for? You may have access to some claims data where you can try to figure out a little bit of, if nothing had gone wrong, what would this surgery that they were in for anyway have cost? Or you might need to, consult an expert on that issue. But I think in particular, don't take for granted on medical malpractice cases that date of accident treatment is all 100% recoverable.
And I would agree with that. And that is a situation when you're first putting the attorney on notice of the lien and sending a copy of the itemization. I always say, please review this itemization carefully. If you identify any issues with this itemization, please contact me immediately. And if they don't contact me immediately, the next time I update the itemization, I use the same language. So down the line, we can't revisit this issue, and I will say, well, gosh, I've sent this for your review, 10 times, and now this issue is coming up. So I try to head it off that way. Doesn't always work, but it's a good best practice, I think, for these kinds of situations, because you don't know. The complication may happen 2 weeks after the surgery, and then you're having to guess, at what point in time does the lien actually start? Does the medical malpractice occur? So, it's best to keep an eye on it and keep good communication lines open.
All right, next, I wanted to introduce, we've got a few questions dealing with what's going on with the Roundup settlement. And so just as a matter of background, obviously, for those of you who don't know, there has been, if you've been living on a different planet for the last few years, there's been a heavy volume of lawsuits related to Monsanto's Roundup weed killer. All of the allegations relate to chronic exposure, so not like one time or two times. It's all related to chronic exposure to the active ingredient glyphosate, I think that's how you say it, which may or may not lead to non-Hodgkin's lymphoma, or at least that's kind of what the plaintiff's counsel claims. The science is far from settled either way, but initial test trials that went on in California a few years back left the plaintiffs with some really massive initial verdicts. And so that started driving the settlement. And there at one point were about 120,000 pending cases. And then there were reports that Bayer, the parent company of Monsanto, had set aside somewhat over $10 billion to settle these claims. Now, that's not to say they've all been settled. Nancy's going to kind of get into what's really going on the ground, but there are still many, many active and open and newly filed cases. I can tell you that the tide has turned somewhat in that Bayer and Monsanto are settling some of the stronger cases and taking the weaker ones to trial. And they've won, I think, the last 5 cases consecutively, and just won one not too long ago down in St. Louis. So with that introduction, Nancy, the question that came in, one of the questions was, how are settlement amounts currently being determined? Do you have any sense of whether this will turn into a class action? And then how would that change how the settlements are determined? So I think that question is going to require a little bit of unpacking. You mind?
Yeah, a lot of unpacking, because I think the better question is not what's been happening with the Roundup litigation, more like what hasn't been happening with the Roundup litigation. Specifically, I think the question came in because a lot of people are starting to see notice letters from Archer, who's been determined to be the lien resolution manager for the massive case that is happening, the multi-district litigation in the Northern District of California. A lot of the cases that were being litigated throughout the country have been consolidated into that MDL action. And probably a letter that you see from Archer says that it was settled in September of 2020, and maybe it was. And if you're able to look online and see the docket, and it does show that certain law firms did advise the court that a settlement had been reached. The hiccup, and it continues to be the hiccup, is the master settlement agreement. So like what Ryan said, the agreement is meant to encompass not only cases that are being litigated now, but also the judge's concern was that the master agreement didn't adequately represent those who would come down with cancer in the future. So again, that is still being litigated. And in fact, in March of 22, Bayer told its investors that it reached a tentative settlement agreement in roughly 98,000 of the cases. So we keep hearing this number, like 100,000 cases have been settled. We're all starting to see Archer notices, like we've been retained to handle the lien. However, I think it's important to note that Bayer advised its investors that it brokered the settlements primarily by negotiating block settlement arrangements with lawyers who have large numbers of cases in the litigation. So that sort of speaks to the question number 2. That's why there isn't a class action on the personal injury side, because factions of law firms, 5 primarily and throughout the country now, have consolidated in this MDL. They're not coming together. I don't see them coming together. But again, Monsanto's trying to, on a block basis, settle with some of these law firms. So that begs a lot of questions from a lien resolution handling standpoint. So the big question, as I said, in the MDL litigation, a special master has been appointed to determine the settlement amounts based on a point system. And we'll get into that next because I think it's important. There are individual suits in the MDL litigation that are going to be moving toward trial, and that's under the basis of standard liability determination and settlement. So to think back a little bit, a claimant has many opportunities about how they present their case. They can work with a law firm, fill out a short order application. They can move to an accelerated settlement, accept an accelerated settlement. And then that makes it interesting for resolving the lien, because the question is, well, gosh, this person had $300,000 in medical expenses, but because they chose this accelerated settlement option, it makes it difficult for you to go back to your ERISA plan and say, well, you know, they were awarded $67,000. And the next question is, well, on what basis? And then how do you come up with a reimbursement determination based on those factors in any fair manner? But anyway, so moving on, I'm just going to go through these bullet points and we can talk about these issues. So the class action that you read about, if you want to Google it, is really on the product side. That's an Oregon case, and that was more about false advertising, consumer fraud, breach of warranty, and other economic claims. And that did settle in 2021 for $45 million. So a lot of the claimants are able to get, obviously, a recovery on that side of things for having used the product. And then if they develop cancer going forward, they're able to get another settlement. Again, none of this is black and white, cut and dry. A settlement has been reached. You know, here's how. It's all evolving. So I'm trying to keep up with it for my clients who are being inundated with notices from Archer. So this is an evolving issue, and I'm sure that we'll revisit again in future webinars. But reeling back to 2020, when everybody thought this was settled, Monsanto Bayer agreed to pay $10.9 billion to settle nearly $100,000 lawsuits from the NDL, claiming that the glyphosate in Roundup and other Monsanto weed killers caused them to develop cancer. So again, the closest thing to a Roundup illness-related class action is that Northern District of California MDL. And then there are consolidated groups of individual cases within that MDL that are moving forward. So if you try to read through the docket, I've tried to block out hours of time to try to read through how it's evolving. You can look at a pretrial order that seems very dispositive of how the case is going to be moving forward, and then Monsanto will push back, as they're doing now. They keep revisiting the master settlement agreement. No one can come to a full agreement on it because of the issue of the future cases. How are we going to handle that? How much money should be set aside? The judge isn't really thrilled with anybody's proposals thus far. So again, it's definitely evolving. So, you know, bear that in mind. And we'll get to best practices about how you can try to manage that. And I think that we talked about that. The 10.9 million was meant to deal with future cases. So the point system, the special master reviews the point system. And not only is there a point system that is determined, but the point system then puts a claimant into a settlement bucket, a tiered settlement bucket. So that further complicates the matter as we are trying to substantiate for our ERISA plan clients how we reach the settlement. It's just another ambiguity there. So the settlement tiers are based on the strength of the claims and the severity of the injuries. And that is only going to be as good as the law firm who's representing the claimant, what their application form looks like and what evolves within the litigation. You'll also find on the docket different applications that are proposed to the court that a claimant needs to fill out. Like Monsanto needs this information to evaluate your claim. They started doing that, but then they realized that nobody on the Monsanto side was going to take the time to look at each and every person's medical expenses, you know, all the things that they said that they wanted, they didn't really want because there's no way that they could be individually evaluated. So the special master comes up with this point system, and depending on the point system, people with higher scores get a bigger payout, and those with a lower point score system end up getting much smaller payouts. So it really depends on the timing of when they became exposed to it, the nature of their injuries, etc. And the smaller payouts are somewhere in the neighborhood of 30,000, and that would be regardless of whether your plan paid $150,000, $300,000 in medical expenses on this person's behalf. So it's not great.
And
so
yeah, let's say the situation where you had a big lien that you were able to identify, and you're trying to wonder why they qualified for such a small settlement. You know, they may have only used the product once or twice, or they may have other risk factors that were driving this lower settlement amount. In other words, lower risk factor, higher risk factors for the cancer. as compared to other claimants who had used it, maybe they were landscapers or farmers and they had used it, their entire careers. So the link, their case was just stronger. In your case, your claimant's case might not have been.
Right. And the other thing is, even when they're considering medicals or medical factors, sometimes it's based on, did you receive XYZ diagnosis? Did you need XYZ type of treatment? But for the point system, it doesn't matter how much that treatment cost. It doesn't matter whether you've got, some kind of cost-effective way to treat that specific diagnosis. It's just yes or no, did X happen? They are not looking at and the settlement agreement doesn't call for them to look at or consider the actual bill amount or pay amounts for that matter.
Exactly. Even though earlier on in the litigation, of course, they wanted to look at all of that very specifically. It definitely has changed from that. So what do we do with this information? What can we do when we receive a notice from Archer that, well, it's a little bit of a fuzzy notice letter because it's not very clear of exactly who they're representing. So that's number one. Once you review their letter word for word, because words matter, you'll quickly come to realize that the person who's sending you the letter is sending you a form letter, and very often they're ill-equipped to answer your specific questions. But that shouldn't stop you from getting preliminary answers before you even entertain any kind of a reduction. So you want to find out exactly who Archer is representing, and likely you're going to come back and say the court ordered, or they will send you a protective order authorization, and on that it will identify usually which law firm the settlement is attached to. The claimant is associated with that particular law firm, and so I think it's reasonable to ask which law firm is the claimant being represented by, and that can give you a feel for that law firm's process of, do they really spend time with their claimant? Do they really push back when a settlement is reached? They do have the opportunity to appeal. You can kind of get a sense for that.
Nancy, just to kind of further unpack that, when you say who is Archer representing, Archer's not representing Monsanto or Bayer. I mean, in this case. And
nor are they.
That does happen on occasion, right? And that can change how you would want to argue with the vendor. But in this case, they're retained by the plaintiffs, right?
Right. It's a court-ordered lien resolution manager for this particular litigation. So they were the, drew the lucky straw, I guess, or ended up getting that business. I'm not sure how thrilled they are about it right now, but that, that's who everyone is dealing with. Number two, find out if the settlement is final. If the settlement is not final, because they will send you a letter that says something about a potential settlement, you'll want to push back on that a little bit. Well, is it potential or did it actually happen? And is it approved by the court? I think that's important to find out. The other difficulty people are having is actually getting a check. So you'll want to find out, because it's happening one of two ways. Are the funds immediately available if we end up settling? And where are those funds held? Does Archer have those funds? Sometimes they do. Does the law firm have those funds? Sometimes they do. You want the answer to that. And then you'll want to find out the gross settlement amount awarded to the claimant. You want to make sure that is the gross amount, because they tend to throw around net settlement within their notice letters. So push back on that a little bit and get confirmation of that. Find out if there are any other lien holders, because what they won't tell you is, well, I'm going to settle this with you, and then there's a Medicare lien, and it's going to take 4 to 6 months for me to get in touch with them and to resolve that part of it. In the meantime, you're like, we settled this months ago. Where's my check? So you'll want to find out who the other lien holders are and what their interest is, because after a while you start to realize that you've got this huge lien, a very small settlement, and other lien holders. It becomes difficult to come to a resolution on these. Big important point is that often they will ask you for an itemization, that they want to audit the claims, And the reality is Archer has hired a third-party auditor to aggressively deny claims. It's astounding to me that a diagnosis code will come back with, non-Hodgkin's lymphoma all over it, and they will say, I've actually had one that was $169,000 lien that they reduced to zero, saying that none of the claims were related. Absolutely untrue. Reject their audits or claim to close your file. The other thing that's happening is that within Archer and some of the TPAs, there are special groups that are working together to resolve these Roundup claims. And they're not speaking to the normal TPA, and don't really want to name names. And my clients have gotten letters saying, oh, these are duplicate claims. We've already settled with Rawlings. Close your file. What? And then you have to dig into that. But it's happening. So you just have to be very careful. Argue every time attorney's fees. 40% off the top, argue. What did they do for that 40% fee? What was done on their side? And Archer will tell you, I will get that information for you. And then 30 days will go by and you won't get the information. And 30 days will go by and you won't get the information. They are actually going back to the law firms and asking them the questions that you are asking Archer. They feel that they're legitimate. For those of you who have escalated to supervisors and legal counsel within Archer, they are trying to do the right thing. They're just not getting really good responses from their clients. But be assertive, stay on top of it. And then if you do resolve a case with them, attach check receipt timeline with it and make them respond to you. Can we expect a check within 45 days? Make it something reasonable, but don't agree to a final settlement until you get that information. Otherwise, I think that we're all going to be out here with these $100,000 settled cases, not ever getting paid. And that might even include the claimant. They may not have gotten paid. And don't get bogged down in communications with them. If they're not understanding what you're asking them, for instance, I asked at one point in time, what case was this claimant involved with, the MDL litigation or one of the state court claims, and the person sent back my client's claim number and my firm's claim number. So somehow transposing that question into, well, your claim number is, I was like, no, case number. Don't get in the back and forth with them. I don't believe that they're doing it just to waste your time. I don't think that they are trained well enough to understand your legal questions and the assertions that you're making. So feel free to, be a Karen, ask for the manager right away. Don't spend administrative time going back and forth with them via email or any other communication. That's just eating up administrative costs. I would advise don't do it.
So a couple questions then. If we're not getting anywhere on a particular claim, what are your thoughts? And this goes to Nancy and Catherine. What are your thoughts on? Well, should we just file a 502A3 action, or should we just file our own sub-row action against Monsanto and Bayer that would get consolidated in the MDL? It would probably, get stuck there. But what are your thoughts on reimbursement, subrogation, and should there be any litigation over this?
I would like to see a 502A3 action happen and have the court understand from a lien holder's perspective what this litigation is resulting in. I think that would be very interesting. And I started to talk to my client about it, but like everyone else, the ability to get answers and to resolve these cases with Archer is relatively new and unfolding as we speak. So I think it would be a good idea. As far as getting involved in the MDL on a subrogation basis, I think you would just get lost and it would take even more time. And the difficulty is when I'm dealing with my client, these health plans, a lot of them are very close to their employees who have cancer and are affected by this or have passed away. There's the human element to it too. So, but the plans are starting to get unhappy with the way that this is evolving. And I think that someone is going to bring a lawsuit. And I don't think it's a bad idea.
Yeah, I'd agree with that. I think some kind of reimbursement action, and part of the problem is obviously we need to think about who's holding the funds, who needs to be involved in that. But the other thing to consider with a subrogation action is, remember, we're not always getting extremely clear answers about whether or not the actions have formally settled. And obviously, one of the many hurdles in bringing a subrogation action is if these claimants have settled, even if it's for, ridiculously low amounts with ridiculously high attorney's fees, that may void your right to bring any kind of action directly against Modesto.
Right.
All right. Well, if you've got any other roundup questions, feel free to shoot them over to Nancy. I'll designate her the point person here on any follow-up roundup questions. But moving on, our next question centers around cooperation. And Catherine, I'm going to turn this one over to you. In some states, we get a lot of pushback from plaintiffs' attorneys if we attempt to communicate with the at-fault carrier. Is that something we should be concerned about? And secondarily, how do we get the at-fault carrier to cooperate with our lien? I actually think that this person mentioned we want to avoid a Montanil situation. We just want to find out when the cases are settling. What do you think?
Yeah, so I think there's a few aspects to this. I definitely understand that, particularly when you're dealing with plans that get really good discounts, for example, where the paid amount is substantially lower than the charge amount, and particularly if you're in a state where the plaintiff is permitted to assert charge amounts in the underlying litigation. I understand plaintiff's counsel's concern that they don't want these reduced itemizations going to the adverse carrier, because as much as the adverse carrier shouldn't be doing this, they're going to turn around and say to plaintiff's counsel, well, we're not considering all the billed charges, even though those are legitimate damages that you could have proven at trial. And so I think there are a few things you need to consider. Step one is just, obviously, if the patient is represented by counsel, you want to talk to them. If they're not for some reason, and this is a rarer situation, talk to the patient. But you want to think about how this is going to play into your strategy long term. Is this a situation where it's going to be better to secure the attorney's cooperation early on and develop a rapport with them rather than making them angry with you right off the bat so that they're going to be more combative when it comes time to settle? There are attorneys that I've come to agreements with where, as long as they respond to my requests for status in a timely manner and they give me all the information that I'm looking for, and this is key, as long as they have given me the adverse's information to use if I need it, I will agree to, at a minimum, hold off on talking to the adverse. But that's an agreement that you definitely want to get in writing, and you want to make sure that you're following up pretty regularly with plaintiff's counsel. You don't want to have one of these situations where you track the file out 6 months, oops, all of a sudden everything's fallen through the cracks. If you get to a situation where you are working with the adverse and you're having a challenge getting them to cooperate, one thing to think about is, how are you framing your claim to the adverse? Because a lot of times what we get is, oh, well, this is plaintiff's counsel duty to sort out. We don't have to deal with this lien. And that may be true, because remember, it's only the plan participant that has any kind of reimbursement obligation to you directly. But think about, do you have direct subrogation rights that you could be pointing out to the adverse carrier and say, hey, no, we're presenting you with our claim, and while we might be willing to, work with you so that you can settle everything all at once, we have direct rights against you, and so you can't settle around us. You need to include us in those settlement discussions. In extreme situations where you can't get anybody's cooperation, the other thing you might want to consider if the case is in litigation is is this a situation where we actually want to directly intervene in the underlying litigation, assuming our plan terms and the applicable law allows for that? To say, look, we're going to formally present our claim, and we're going to make absolutely sure you can't settle around us by actually intervening in the underlying case.
And that kind of dovetails to the next question, which is talking to plaintiff's counsel. So someone writes in, what are the questions to ask an attorney to get the best current information? So I would suggest that you should maybe rethink your entire way of dealing with plaintiff's counsels. You know, I mean, if your system is such that it is limited to generating automated faxes that go out to plaintiffs' firms asking for an updated status, that if you're really interested in getting an answer and building a rapport on that claim, that you do it a little bit differently. And so our advice here is to rather than relying on these automated faxes or vanilla emails that you send out, if you're really interested in finding out what is going on with the case and what kind of case it really is, I would encourage you to pick up the phone rather than relying on those written correspondence. And Catherine reminded me when we talked about this in advance that, look, if you send over a fax with a status request, you know, maybe it's even got a box that just says case in discovery. That's all you're going to get back. All you are going to get back is the minimum amount of effort that the plaintiff's counsel or their staff will put into responding to that kind of a status. So if you're genuinely interested in what's going on, the best way is to get on the phone and talk to that attorney about what's going on with the case. Because rather than taking 30 or less than 30 seconds to check off, you know, cases in discovery and fax it back to you, you're likely going to get maybe 4 or 5 minutes, maybe 10 minutes, who knows, to talk about what's going on in the case. Now, the plaintiff's lawyer may tell you it's a crummy case for X, Y, and Z reasons, and you know, we just took a deposition of so-and-so, and they completely contradicted my client's whole case. But you'll have all that really juicy, good information, which is what you need when you're making an evaluation later on in the case. But I would encourage you to familiarize yourself, you know, generally with how cases progress, so that if you want to ask the certain questions on the call, you understand that generally the cases get filed, then they go to a scheduling conference, then there's discovery. There's usually written discovery first before there's depositions, and then after there's depositions there might be expert discovery, and after expert discovery there's going to be a mediation. And once you kind of understand how the cases normally progress, you can start asking questions to the plaintiff's counsel that give you a little bit of more insight as to where the case is, where it's going, and even, you know, talking about, is there a summary judgment deadline? Is this a summary judgment case? And so that there might be legal issues. But ultimately, I would kind of be thinking, if you're looking for how to tease out a conversation, understand how cases progress, and ask about specific questions related to where the case is in that time frame. And then obviously, if you're able to ask open-ended questions, so that the plaintiff's counsel can give you more of a narrative response about the case, rather than, again, relying on some of the more generic emails or faxes about where the case is in any particular time. Catherine, Nancy, any other tips for talking to plaintiff's counsel?
So I'd say that once you really start to learn what the different junctures of litigation are, talk to plaintiff's counsel about, is there a particular point where you think settlement discussions are likely gonna start meaningfully progressing? So oftentimes that's after the close of fact discovery. because the parties don't want to have to engage in expert discovery, or they don't want to have to file a motion for summary judgment, because those are things that are going to be expensive and time consuming for both sides. Sometimes during fact discovery, it's after written discovery has concluded, but before anyone actually has to sit for a deposition. And so oftentimes the lawyers who are handling the cases have some idea of where in that progression they're most likely to have settlement discussions. And so when you're having those initial conversations with plaintiff's counsel, if you can get that point, you can, make sure that before those deadlines come up, you have an updated list and all the documents that you need. You can alert the plan that, particularly if it's a larger lien, we expect that there may be a mediation on this date and we may need somebody available, or we expect that discussions are going to start around this time. And so this might be a good time to check in or to expect to hear from them, things like that.
I agree with all of that. And definitely if there's a mediation, you want to find out the date of the mediation, and then you advise that, shortly before the mediation, I'll be providing you with an updated itemization and my cell phone number. If there's any chance of resolution, we don't want to impede settlement, so please feel free to give us a call, and then I advise my client as well. That's a pretty key point. If you followed along and there's no settlement discussion after the deposition, sometimes that's a really key part. After a couple of crucial depositions, the parties realize they need to come to some kind of a settlement.
Mm-hmm.
So I agree with all of that. But definitely get a hold of the docket, follow it, let them know that you're following it, and keep communications open. It's a good way of doing it, other than just putting the onus on them. Try to actively engage if possible.
Where's the money? That was the next series of questions. And it's questions that clients ask us all the time, is really, how can we get the money in? Basically, how do we get the money in the door faster? We've got a lot of situations where, whether it's a lien resolution vendor like Nancy is talking about, or it's a case that we thought we settled 3 months ago and we still haven't gotten the check. So obviously there are cases that are delayed for whatever reason. Maybe it didn't settle like you thought it did. But I kind of want to focus this answer to give you a little bit more practical guidance, I guess, as to what happens, from mediation to the time that you actually get a check. And what is a reasonable expectation of when you should be receiving that check? And why can't you demand that they just send the check to you directly? So first of all, obviously, we've got a settlement maybe at a mediation, for example, and you were called and you negotiated the lien and you thought you had a resolution at a certain amount, and you're kind of like in your head expecting that, well, in 30 days I can diary and I'll get my check. And very rarely does that actually ever happen. So I think you need to kind of put in perspective, and depending upon what kind of case it is, but is that there's a lot of steps in between settling a case at a mediation and then actually the check coming in the door, and then finally the check going out the door to you. So first of all, you've got an agreement to settle the case at mediation, but it's always going to be subject to certain releases and settlement agreements that the lawyers go back to their office, they start drafting these things. They can get more complicated and more drafts depending upon how many different parties there are in the litigation, multiple plaintiffs, multiple defendants, and that process takes time. Typically it can take 2 weeks to get a draft release settlement done. And in the meantime, liability carriers who are funding that settlement aren't going to be ordering their checks until they've got a signed settlement agreement and release from the plaintiff. So that can take a long time. I'll hit Catherine up on a couple of these about the government-related cases and why they might take longer to pay. But you've got to keep in mind that if the liability carrier is waiting for a signed release before it's going to order that check, what has to happen is the plaintiff's counsel has to have a visit with his client. His client has to be able to schedule a time to come in and sign off on that paperwork. And in addition, when that client comes in to sign off on the paperwork on the release, they're going through, a settlement disbursement form. And, that takes time to assemble and get that part of the process. So oftentimes, it's not uncommon for it to be at least 30 days from the mediation before any of that really takes place. And then I wanted to remind you that even once the check comes in to the plaintiff's counsel's office, we all are subject to trust accounting rules. And so we'll get a check in, and it has to be deposited and cleared and sit in that trust account for a certain amount of time that's required by statute before any funds can be dispersed. And again, I had mentioned that, we also have to wait until that settlement disbursement statement is signed before the plaintiff's counsel can release any funds on that case. So in other words, he can't pay you your lien amount until he's got something signed in writing from his client that says it's okay to disperse. I'm aware of these liens. I'm aware of this this medical provider bill that's being paid out of the settlement. All of the costs that come off are being signed off on. But there are other types of cases that can just typically take a lot longer to fund. Catherine?
Yeah, so in addition to cases like the mass torts, which can take forever, I've dealt with cases specifically dealing with governmental entities as defendants that can easily drag on for 6 months after the settlement. And some of the reasons that can be true is that often the entity or the person, not the entity, that shows up, let's say, at a settlement conference or negotiates a settlement on behalf of the government entity, isn't actually the person who has final approval. Those can often have to go through, let's say, a city council meeting or approval in some kind of public manner. And so I was actually personally dealing with a case. It was, a 6-figure recovery for my client, but they had to post a notice that it was going to be heard at a city council meeting in 60 days time. And then somebody actually showed up and objected, which triggered another 90-day clock where it had to be approved at a subsequent meeting after essentially those objections had been publicized, and people had been given time to adequately consider them. And so, we made the actual agreement as to the amount to settle, and everybody was very confident that it was ultimately going to be approved. But plaintiff's counsel didn't actually see that money for over 6 months.
So true, so true. Well, I've got a couple more questions that I wanted to get to. We'll try to run through them fast because we're already at the top of the hour. Catherine, this one's for you, and I think I'll save the last one for Nancy. So this one has to do with workers' comp claims. When it's a self-funded ERISA plan and we're on both sides of the issue, so the employer is essentially arguing against the employer. There's a legal cost to intervene into the work comp claims. So should we be? Or do these claims simply end up getting waived as a part of the work comp settlement? What do you think, Catherine?
Yeah, you need to be talking to these plans. The policies that go into place are often going to be done at a plan level. This isn't something that is often handled at the TPA level, which I know can make it really challenging for lien resolution, not for lien resolution vendors, for subrogation vendors. But you need to know early on, for starters, are they self-funded for both? A lot of plans are, particularly if they're larger, but some of them are going to be self-funded on the health side, but they're actually going to have an insurance carrier involved on the comp side. And so the plan does actually meaningfully benefit if we can get some portion of the work comp settlement. If they're self-funded on both sides, what I often see is that they don't want to pay a recovery vendor essentially to tell them to move money from one bank account to the other. And so they may tell you to close those files. And if that's going to be the instruction that you're going to get, you want to be getting it early. Don't waste time, potentially being told by a judge that you have to intervene only to find out at the last minute that the plan has either wants to handle this themselves because they know that the money is just going from one bank account to the other, or they really do intend, and this is a pretty common strategy, to use a waiver of the lien as a way to negotiate a better settlement. If they do want to pursue, make sure that you are in contact with whomever is representing the plan, and if they are, particularly if they're fully insured, whoever's handling for the carrier, because you don't want a situation where something is signed that says, not only is this a disputed settlement as to liability, but we're expressly saying that there are no medicals involved in this workers' compensation, which is a shockingly common thing. That's a pretty standard work comp settlement. And so if somebody signs that on behalf of the employer, there's a pretty strong argument that that waiver is going to apply to the plan later on. And so you want to make sure that you're involved in any settlement agreement or any stipulation before it gets filed. The other thing I'd mention is that this aspect of talking to the plan early, finding out how they're funded and if they want you to pursue, is something that you should also be considering in med-mal cases where the actual plan is a medical facility, particularly if it's if you know for sure it's where the treatment was administered. Sometimes that can even be complicated. Sometimes you want to reach out and say, do you have affiliation with this medical center, even if you're technically differently named.
Thanks, Catherine. Last but not least, very important, are legal referrals. This is not necessarily a planted question on my part about when you should send me the cases. The question can be read a couple different ways. Basically, what should we look out for with our communications with counsel or facts of the case to determine if we should escalate a matter, and when should a case be referred to counsel? And you don't have to read it as just outside counsel, but when should you as a claims handler be referring it up your chain, up to your general counsel for review? Nancy, do you want to touch on some of the factors that they should be considering, or what events might trigger a legal referral?
Yes. Number one, disbursement. If you get a letter saying, oh, we dispersed those funds a month ago because of X, Y, or Z, any notice of disbursement, you definitely want to get involved, take action immediately. Self-funded ERISA plan, you don't want to wait. Settled cases. Montanil letters were very popular. I haven't seen one in a little while. It basically says, we've settled this case. You have 10 days to assert your authority to any of these funds. Otherwise, we're dispersing. Definitely, that should raise a red flag for an immediate response and escalation. Anything with a clock, any kind of statute of limitations situation when you're not getting a response from the attorney that you're dealing with for the claimant, you definitely want to take a look at possible litigation. Attorneys who won't return your calls or respond to you at all. I found that sending a draft ERISA 502A3 complaint will get a return call, but don't tolerate that. That goes against likely your plan's duty to cooperate, and there are some self-help mechanisms you can look at, but you want to be careful with that. Also, any demands or 1024 document requests, if you get any of that, you want to make sure that you are digging a little bit deeper, trying to find out exactly what is going on. And in any case involving a minor or death claims, you want to make sure that those parties are on notice and that you are actively involved. And that could take some finesse, as we in prior webinars have talked about minors claims and death claims. So I think those are the hard-hitting situations that you want to be aware of and escalate. And again, we take calls and answer emails all the time on questionable, here's what we got, what should we do about it? We can often point you in the right direction, give you some pointers on how to, craft a response that will get you back on the right track. Happy to help on any of those.
All right, well, thanks, Nancy. So just to wrap things up today, I've got a little bit of an announcement. So the health webinar is going to be going on a hiatus for the holidays. So November and December, we will be off, and I can already hear the collective sigh of relief from the audience. But we will be back in January and ready for some more. So in the meantime, feel free to contact us with any topics or ideas you might have. You know, if anything comes out that's breaking, be sure we'll definitely cover that in January. There's some other topics that I know that I'd love to touch on that we haven't yet, and that's Medicaid and FEBA subrogation. We also, I know I want to talk about defending against I guess we'll just call it wrongful subrogation claims and the trend of class action claims against plans over wrongful subrogation. But lots of interesting topics for next year that we will we'll jump on starting January. So we'll get an announcement out back sometime in December, so you can put it on your calendars. But everyone out there, enjoy your holiday season, and we will see you back in January.
Bye. Thank you.